All right.
We'll give you the option to continue.
Yes, I did.
Okay, so with that, we'll go ahead and get started, and you're going to be hearing from me first this morning. Again, just by way of introduction, you've got Christine Taylor, who's our executive director of the Office of Institutional Equity and Compliance, and myself, Sarah Zafar, who is the Title IX coordinator. Chris, do you want to move the next slide?
Oh, I thought that maybe, okay. Technology is not perfect. There we go.
Okay. All right. So this is a rough agenda of what we are going to be covering today, and we are going to touch on all of these topics between this first session and the second session, which is scheduled for December 1st at 9 o'clock. So if you haven't gotten the information for that yet, at least on your calendar, and you're able to make it, go ahead, and then we'll get the Zoom links out before that. So we are going to be updating you on just the legal landscape, the new Title IX regulations. That's going to be a big part of what we cover today. VAWA and the Clery Act, just the basic hearing panel competencies, the expectations of hearing officers, our specific policy 3.06, which we will get into in great detail, the roles and responsibilities of the hearing panels and decision makers, how to serve impartially, some tips there, conducting a legally compliant hearing process, compliance with the regs, and also with just the due process requirements that we are under, practicing some relevance questions, talking about evidence, evidentiary standards, best practices, making the actual written determination, drafting the determination to be in compliance with the regulations, and then adjudication of an actual hypothetical, which is what we will do for part of the time next time. All right, so this is Title IX. This is it. This is what it says. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. So that is basically all of higher ed, including private and religious, because of the financial aid agreements that are in place. There are very few educational institutions that are exempt from this. It includes K through 12, again, public and private, if there is any financial aid or federal assistance happening there. And that's it. So that is Title IX. It's very short. It was passed in 1972. And now we have new regulations. So just by way of sort of history, the Title IX regulations, the last time regulations were passed was in 1975, like actual law regulations, and they were not so robust as what we have now. Back in May of this year, the regulations were finally released. The draft, or the proposed regulations, were released in November of 2018, and it took them that long, about a year and a half, to actually release the final rules. And so that's what we have now. So it is enforceable by the Office for Civil Rights. We just refer to that as OCR throughout this presentation, and that is the OCR for the Department of Education. There are other departments that have OCRs as well, but this is specifically for the Department of Education. And in those regulations, they set forth very specific prescriptive due process protections for respondents. They're meant to protect everybody, but it really is focused on the rights of the respondents in our cases. And the major change for a lot of schools, including WSU, was the addition of a hearings process. We did not use live hearings. We had lots of reasons why we didn't do that. Some schools did. In the state of Kansas, KU, University of Kansas, was already using a hearings process, but most schools were not. In the Sixth Circuit, which is not us, obviously, there was case law that required them to start using a hearings process. Probably, I think most of them came up to that about the beginning of 2019, sometime mid 2018 is kind of when that all came into effect. And so those schools were, it's been interesting to observe that. And then, so for us, that's new. The hearings process is one of the biggest things, and that is why you are all here. And then the new policy updates that we had to make in our sexual harassment, discrimination, and retaliation for employees, students, and visitors policy. Before that, we had two separate policies, one for students, one for employees and visitors. We combined those. We were already in the process of updating a lot of our policy anyway, and so this was an opportunity to really bring a lot of that together. So we did that, and then the new regs that preempt the state and laws. I mean, that's, the regs are it, essentially, in terms of what we have to follow. So now we are required to adopt this grievance process that complies with section 106.45 of the new regulations, and that's for formal complaints, and formal complaints are defined in section 106.30, and there are other sections of the regs. Those are the ones we focus on the most because that's where the meat is. And most of it, I would say, we were already doing pretty much in compliance in terms of the investigation side of it. The determination side is what's changed. So that now requires a live hearing model. So that includes cross-examination. I don't love the term. I think it's confusing with actual cross-examination, but it's essentially questioning. It's sort of this indirect questioning from the other party to, you know, like if it's the complainant, they can ask questions of the respondent or other witnesses, but it cannot be directly. They can't ask the questions themselves. It has to go through an advisor. So we've done an extensive advisor training as well to try and meet that requirement. And then cross-examination / questioning of all the parties and witnesses. Again, it really is just indirect questioning of statements that have already been made. So, you know, I can see why they call it cross-examination. It's not supposed to be so confrontational or adversarial. This is an administrative process, but that's how it is. That's how it's set up. And then the other main thing is to make sure that people who are entitled to notification have the information about the process, how to report, how to file a complaint, and then the university's response. And so we do a lot of outreach and letters that have all of that information in it. Okay, so the Title IX team is myself, the Title IX coordinator or designee, and that's going to look different at different institutions, just depending on staffing and other requirements. And so the Title IX coordinator, like I will more than likely also be the investigator a lot of times in these cases, and so I would designate Christine, or in some cases our equal opportunity coordinator could be the designee, just depending on what's happening in our office at that time. But it's the coordinator or designee, the investigator, the decision makers, which would be you all, which would include one chair and two panel members, and that is going to be just, you know, we'll have a roster and we'll just kind of go down the list until we come up with people who are able to do that based on their schedules and availability and that kind of thing. And then also an appeals officer, and there actually would be sort of two separate processes to that appeals process as well, and we'll kind of get into that. And then advisors. So each party is required to have an advisor for the hearing. They may have an advisor for the investigation that leads up to that. Okay, and so the coordinator has the primary responsibility for coordinating our efforts related to things like intake, investigation, resolution, and implementation of supportive measures. And we'll talk about what supportive measures are in a bit. And the goal is to stop, remediate, and prevent. So stop, remedy, and prevent discrimination, harassment, and retaliation that is prohibited under our policy. The investigator is the person or sometimes persons charged by WSU with the task of gathering the facts, doing the interviews, that kind of thing, assessing relevance, synthesizing evidence, and compiling the information into an investigation report. That, you know, they don't want the investigative report to influence the decision-making process, yet we still have to do this relevance assessment. The investigator is the one who, you know, we do all the interviews, we create statements, we look at the other evidence that might be available to us, and then we are tasked with then kind of putting it all together, putting it into a report, creating the timeline, all of that kind of stuff. And it's very difficult, I think, to not have some influence on the process, but we are sort of going to try to keep that as separate as possible. And then the decision makers, the hearing panel, hearing officers. So that is you all who would have the decision making and sanctioning authority. So two separate things: the determination of whether policy has been violated and whether the respondent is responsible for that, and then the sanctions that would be appropriate to that, and that would be within our process. And then the advisors, who can be a person who's chosen by the party or appointed by the university, and that would be from our list of folks who we have trained. That person can accompany the party, either the complainant or the respondent, to meetings, interviews. They can do some advising, some guidance through the process, and then their primary role in the hearing is to conduct that cross-examination, essentially serving as a mouthpiece. The party cannot do the cross-examination themselves, so the advisor is the one who actually has to do that. But we, you know, that's kind of the bare minimum, and so we have trained on also the advisors being able to kind of help the parties through what questions are appropriate to ask and that kind of thing, you know, what's relevant and that kind of thing. So it's a little bit more for us than just a mouthpiece. And then you've got the parties, complainant and respondent. So the complainant is the individual alleged to be the victim of the conduct that could constitute harassment or discrimination or retaliation for engaging in one of those protected activities. And then the respondent is the individual who's been reported to have engaged in the conduct. So pretty straightforward in terms of what those definitions are, the complainant and respondent. The formal complaint, that is also a new piece to our process. It is the document that is filed or signed by the complainant or the Title IX coordinator in the event that a complainant doesn't want to, but we feel that it is still necessary to go through an investigation. That is a way that the Title IX coordinator might sign the complaint, and that would be alleging harassment and discrimination. And then it would be against a respondent, and then requesting that the university actually formally investigate the allegations. It can be a physical document or an email, you know, online, electronic, and it's going to have the complainant's physical or digital signature. Now, the way that this typically is going to work, we use a data management system called Maxient, and people file their reports through that. And depending on the level of detail and what they're asking for, the form says, you know, what is it you're asking the university to do and that kind of thing. We can use that as the formal complaint if it's got all the information. Now, if the complaint, or if the report is filed by a third party, then there would be a separate step there. But essentially, it is just the allegations, you know, what's going on and what do you want someone to do? What do you want us to do about it? And then again, if the Title IX coordinator signs it, the Title IX coordinator would not be the party, would not be considered the complainant. It still would be the person who was affected by the conduct. Major changes to our sexual harassment definition. Sexual harassment encompasses the sexual harassment that we sort of think of in those employment contexts: sexual assault, dating violence, domestic violence, and stalking. So those are all encompassed within sexual harassment. And so sexual harassment itself is conduct on the basis of sex, either sexual or sexualized conduct, It can be quid pro quo, the something for something, that you're conditioning provision of an aid, benefit, or service on the individual's participation in unwelcome sexual conduct or sexual harassment that is unwelcome conduct determined by a reasonable person to be so severe, pervasive and objectively offensive, that's new, that it effectively denies that person equal access to the program or activity. It used to be severe, pervasive, severe or pervasive, and now it's and. So that's very narrow.
Sorry.
No, you're good. Okay, one more. There we go. Okay, so sexual assault, what we mean by that is one of the following sexual offenses. So it's pretty specific when we're actually talking about what sexual assault is. It can be forcible or non-forcible, and it is directed at another person without consent, including incapacitation. So rape, fondling, I'm not going to go into the specific definitions, but they are here for you and you will have these materials. But rape, fondling, and these definitions come from federal, it's the NIBRS definitions is what they're using right now. And I think that's actually subject to change again, possibly in January. So that we may update these a little bit. And then there's a couple more on the next slide. So incest, and then statutory rape. In Kansas, that's the 16 years is the age of consent. So pretty self-explanatory, but it is just those four that constitute sexual assault for the purposes of our policy and definitions.
And we don't see incest or statutory rape typically.
Not here, that's not, yeah. And then you've got dating violence. And dating violence is defined specifically as violence committed by a person who is or has been in a social romantic relationship, of a romantic or intimate nature with the complainant. And the way that they determine that is actually pretty similar to how the state statute of Kansas does in terms of length of the relationship, type of relationship, frequency of interaction, all the things they're looking for when they're determining whether it's a dating relationship. And it includes sexual or physical abuse or threats. And it does not include acts that would be covered under domestic violence. And it's a very similar definition, but there are some differences. So domestic violence for the purposes of our policy is defined as felony or misdemeanor crime of violence that is committed by the current or former spouse, whether they share a child in common, by a person who is cohabitating or has cohabitated with the complainant as a spouse or intimate partner. That is a distinction from the state statute. It's by a person who's similarly situated to a spouse, or by any other person against an adult or youth complainant who's protected. So, by our DCF protections. And kind of the major change, the thing that I want to emphasize is that to categorize it as DV under this policy, as domestic violence under this policy, the relationship between the respondent and the complainant has to be more than just roommates. It can't be just people living together who are not in some way in an intimate relationship, or one of those other definitions where they have a child together or had a child together or something like that. So what that does is it changes how we classify the incidents at the university, because prior, we have a lot of roommate cases. We have a lot of roommate physical, scuffles, fights, those sorts of things that had to be categorized as domestic violence prior, and we're not doing that anymore because you have to have that element of intimate partner or spouse in there for it to be considered domestic violence for our policy. So that's going to be, I think, the major change from the deviation from statute as well. And stalking is the course of conduct directed at a specific person that would cause a reasonable person, again, that reasonable person standard, to fear for their safety or the safety of others, or to suffer substantial emotional distress. And so the course of conduct, again, 2 or more acts including but not limited to acts where there's either direct or indirect or through third party, or device, drones, that kind of thing, follows, monitors, observes, etc., threatens, or communicates to or about a person or interferes with their property. So that does include, we've had cases where there's a parking facility at one of our residence halls and people mess with each other's cars and things like that, and that would be considered interference with their property as well. Obviously the reasonable person standard, a reasonable person under similar circumstances and with similar identities to the complainant. So, it's got to be somebody sort of similarly situated when we're looking at that reasonable person standard. So we're not being super draconian about what that means. We're trying to assess what a reasonable person in that same type of situation would react, how they would respond. And then the substantial emotional distress is that significant mental suffering, anguish, but that may or may not require medical or professional treatment. And that is a case-by-case analysis. There's a lot of things to look at there. There's not really a specific, line that like, oh, this is substantial emotional and this is not. It's really case by case, and it's all of those things together that we're looking at.
This particular definition has given us, it does not allow us to differentiate between working, which is something that we see quite a bit, and stalking, basically, which is much more serious and can really end in a violent interaction. And this particular definition versus the old definition is really missing that menacing piece. And it doesn't allow us in our office to really deal well with some students who may be on the spectrum, and because charging them with stalking isn't going to help the behavior, and the sanctioning isn't going to help because it won't change the behavior of that individual. So, we see this quite a bit with students that are on the spectrum, and this particular definition is really removing our ability to have an educational conversation with them. And so we're trying to balance what we are required to do, and balance the issues that come along with some of these cases that are not necessarily true stalking cases.
Yeah, and that's tricky, because again, those lurkers, that's essentially what we call them. Prior to this, we could assess that, and we could say, okay, what's really going on here? Is this a situation where we just need to talk to somebody? And this does remove that ability because they don't make a lot of distinction there. And so, we still have the option of informal resolution if everyone agrees to that. But yeah, it has taken some of the nuance out of it. And then, so we use that preponderance of the evidence. If it shows, this is just kind of important to look at when you're looking at decision making. If the preponderance of the evidence shows that it is more likely than not that the conduct occurs, the decision maker does not have to do an analysis of severe, pervasive, objectively offensive for sexual assault, dating violence, domestic violence, and stalking. If it's determined to have occurred, because by definition, it is severe, pervasive, and objectively offensive. And there is that finding. And so if we're looking at sexual assault, dating violence, domestic violence, or stalking, we don't have to do that severe, pervasive, objectively offensive analysis, but you do for the sexual harassment and quid pro quo. We still are required to do it for those. All right, and so then now we have those other sex-based offenses. So discrimination on the basis of sexual orientation, gender identity, or gender expression. That's the differential treatment on the basis of those specific protected characteristics. And then discrimination against pregnant and parenting students. So again, that differential treatment. And I mean, I've seen this with pregnant and parenting students. It goes to, you know, even well-intentioned differential treatment still can be considered differential treatment and could be considered discriminatory. Those other sex-based offenses we are going to use a different process for, but we'll get into that. And then, so now it is essentially, you know, what happens when we receive the report. So,
So when we receive a report, and we, again, I would say the majority of the information that we receive comes through our Maxian system.
yes.
And what we do is when we receive a report and the individual impacted or the complainant has been identified, we respond to every report. We will send an outreach letter explaining who we are, what we do, that we have supportive measures, what their options are, and the process for filing a formal complaint. We send that out. We invite them to contact us if they would like to meet with us to discuss this further. We don't force them to come in and talk to us. We don't schedule a date and time. You know, we don't say in the letter, well, based upon your school schedule, it looks like you can meet with us on these days and these times, so come in on this day and time. It's really very much up to that individual impacted. And we are required under the regulations to investigate every formal complaint. And that's the formal complaint that Sarah talked about earlier, where the individual sets forth the allegations and requests the university to formally investigate this.
Yeah, and I just, a quick note there. The reason that we're emphasizing that it's an invitation, voluntary process is because that is not always how we've done it. It's not always how the university has done it. And there was a time when the letter that would go out from this office would say, you know, here's when you're supposed to come in. And if you don't come in, you know, here's these things that we're going to do. And we have absolutely just revamped that and changed that because that's not conducive to getting information and things like that.
Yeah, it makes us look scarier than we already are to everybody. And I always say to people, it's bad enough when you have to leave messages that you know, for people that says, hi, it's Chris Taylor and it's nothing bad, you know, because it's coming from our office. So at any rate, this is a real thumbnail sketch of our complaint process and how it proceeds through this, you know, basically our system. And we receive the notice of allegation. If somebody does respond to our outreach letter, we begin reviewing the information and making a determination, even if somebody requests a formal investigation, if in fact a formal investigation is appropriate, we can proceed. Or if it's going to be subject to a mandatory dismissal, which we'll talk about later, or a discretionary dismissal, or if it can proceed. If it can't proceed, then the investigator begins the comprehensive investigation where we begin to call in witnesses, ask for information, such as text messages, screenshots, we look for video surveillance if we have it. And interestingly enough, because nobody talks on the phone anymore, text messages seem to be it. When we get, you know, the screenshots of text messages, that seems to be the most prevalent evidence that we have, and that we've seen in our experience. After we've finished collecting all the evidence, interviewed witnesses, and the parties have prepared their summary statements and have allowed them to review them, make any changes or corrections, we distribute all of that information, everything we've collected, to the parties for their review. And they respond to that. They can respond to it saying we should include this, this, and this, or this shouldn't be included. And we go through that that process. Then the investigator completes the investigation process with a final investigation report. And that essentially goes to you all for your review prior to the hearing, where again, you'll be weighing the evidence, making credibility determinations, and you will be facilitating the cross-questioning or cross-examination. And finally, again, you will make that determination whether or not there has been a policy violation by a preponderance of the evidence and determining what the appropriate sanction is. Both parties have the opportunity to appeal if either one of them or both doesn't like what we did. And then it goes through our appeals process.
And I wanted to, like, this visual is just, that arrow is just super helpful in terms of really being able to visualize the whole process from beginning to end. I think this would be a really good time. So we weren't sure if we were going to be able to do that, but we are working with the Kansas CLE Commission we're pending approval of this to actually get CLE credit if you're an attorney. So we wanted to take a quick minute, just really quickly, if you all could, into the chat, type in your state and bar numbers. We're just going to count that as the first poll question, because we got a poll questions for CLE credit as well. You know, we're pending, so it's not guaranteed yet, but it's just a matter of getting that approval. So if you could just really quick into the chat function, type in your state and bar number to answer that first question. If you are not seeking CLE credit, then if you could just type in, you know, your favorite number or something like that, just so that we can get a response from everybody. And what we'll do is we keep the chat from this, and so it's going to have a record of all of that. So if you can do that. If for some reason the chat is not working, just feel free to email myself or Christine with that information. If you could just take a quick minute to do that. Okay, and I think we can keep going, but if you just want to keep doing that.
Yep. All right, so we are under an obligation as a university to respond in a manner that is not deliberately indifferent to actual knowledge of sexual harassment in an education program or activity. And the regs have changed the responsibilities of the university from having knowledge that we knew or should have known to actual knowledge, meaning our office has received a report that somebody, either me, Sarah, or Mike, received a report of harassment on the basis of sex. That makes us legally responsible to respond. And it has to be the harassment has to take place within a program or activity of the university. So the regulations define educational program or activity very broadly, and this could include Greek housing, off-campus social events sponsored by a recognized student organization, athletic or events at other schools which a university team is participating. So they've really expanded it. And you know, for instance, all of our Greek houses are located, you know, technically off campus. And if they're having a party and something happens, technically we do have control over that. The question becomes, sometimes we have Greek programs that are suspended, but they are still living in that particular house because we don't own the house. The national organization may own the house. So what happens when they're suspended and they are not recognized by the university at that point? Do we have control? So these are kind of the things that we're going to see litigated, and that may arise while all universities are really going through these new processes and under these new definitions. We are required to make a prompt contact, and I can honestly say in our office, it is less than 24 hours. Even if we receive notice over a weekend, we will reach out over the weekend. They will have that outreach letter in their inbox in less than 24 hours. And we work with the complainant to ensure that their wishes are taken into account with respect to supportive measures. What do they feel that they need? What would make them feel safe and comfortable on campus? And whether or not they are comfortable filing a formal complaint, and ensuring that the supportive measures are available to them even if they do not file a formal complaint. And understanding that supportive measures have to be reasonable. For instance, complainant can't request if they are in the same class as a respondent and this is the only section that a respondent get kicked out of class, that they don't want to see that other person. We have to make sure that both parties are able to pursue their academic programming, while the investigation takes place. So we do provide supportive measures that are reasonable. They have to be without cost to the parties and to restore access to the university's educational programming activity. That we have to treat them equitably, both of them. We have an obligation to not only provide supportive measures to the complainant, but the respondent is also offered supportive measures if that person would need them. And you would be surprised. I mean, a lot of respondents are shocked when they get a notice of allegation. A lot of them don't really realize they've done anything wrong and do need supportive measures as well. So here's just a list of some of the things that we do offer them as far as supportive measures. I'm not going to go through them. You can read them. And those are really issues that we deal with behind the scenes before any matters get to you all as the decision makers. Other considerations that we look to are emergency removals. And it has to be determined that there is a risk, an immediate threat to the campus community or the individual impacted arising from allegations of sexual harassment. Not just we think they're a threat to the community because they're unstable or something like that. It actually has to be tied to these allegations. When I worked at Marquette University, there was only really one time where we did an emergency removal, but that removal has to have specific time and conditions on it, and it also has to be such where you can lessen the effect on the respondent as you receive more information. And in this particular instance, the allegations were horrible, but once we started realizing that it wasn't that person, or there wasn't video of the complainant saying what didn't happen in a bar because it lacked video evidence, we started lessening the restrictions and allowing the respondent to come to class on campus and things like that, and ultimately then within less than a week removed the restrictions entirely. So this all has to take place quickly, and the respondent is entitled to have their advisor with them during this emergency removal process. We have to implement the least restrictive emergency actions, and honestly, one of the advantages of having remote learning or online classes is that there is minimal contact. If students do have a course together, there's less of an impact academically to respondents and complainants because of that. But it is our obligation in our office to make sure that they are least restrictive, yet providing the safety measures to the complainant. We also have employee administrative leave. It is paid leave, and we can implement that if necessary during the pendency of our processes. We typically want to resolve these cases between 60 and 90 days. That means investigation through the hearing process. There may be exceptions or extenuating circumstances, and it is our responsibility on our end to make sure that the parties involved receive written notification of the delay and the reasons for the delay. Again, equity of rights. Both parties need to be treated equally during this process, and same with any post-determination remedies that you all will be making if there's a violation of policy and somebody's found responsible, and that some of the remedies can be disciplinary or punitive once a finding is made, but they also need not, and at that point, you don't have to worry about burdening the respondent. If there's a finding of responsibility, this isn't an educational setting. This is Title IX. And in Title IX, there really aren't the soft landings that you get in a conduct case where you can have those educational conversations. So we are required to provide due process that federal and state legal protections apply. We have to provide procedural due process, meaning notice of the charges and the hearing and resolution process, the right to present witnesses, the right to present evidence, the opportunity to be heard and address the allegations and the evidence, and a right to a decision made on based on the preponderance of the evidence, that there has to be due process in the decision or the determination, and that means that the decision is based on a fundamentally fair rule or policy, and that there has to be a rational relationship to the evidence that's substantially based upon, and a reasonable conclusion can be drawn from the evidence, and that the decision is not arbitrary and capricious. Sanctions as well must be reasonable. For instance, we don't separate a student from the university for a single harassing statement. The procedures reviewed apply only to qualifying allegations of sexual harassment. Sarah talked about sexual assault, dating violence, domestic violence, and stalking involving our students, staff, and faculty members. That the procedures also apply to qualifying allegations of sex-based offenses, discrimination on the basis of sexual orientation, gender identity, gender expression, and so on, and discrimination against pregnant and parenting students.
And I think that the distinction there is that, you know, this grievance process, this formal Title IX grievance process, is really going to apply to that first set, and then we have sort of a second process that's not necessarily going to include things like a live hearing, or, you know, a pregnant and parenting student complaint, or discrimination on the basis of sex or sex orientation. You know, those parity arguments in athletics or other programming and things like that would not necessarily fall under this, but are still considered Title IX for the purposes of the regs. So it's kind of a distinction. That's why we break out those two separate categories.
So again, our grievance process begins with a notice that to the complainant, and that we determine the next appropriate steps, and that only an investigation and a grievance process will determine whether the policy has been violated. So once a formal complaint is received, the Title IX coordinator assesses the sufficiency to make sure it is complete. We offer the supportive measures. We inform the complainant of their right to an advisor. We review with them the informal options, the informal resolution process. If the complainant wishes to pursue the informal options, the Title IX coordinator then needs to determine whether that process is suitable, and will reach out to the respondent to see if they are willing to engage in the informal process. Otherwise, the formal hearing process will begin. Written notice must be provided to the respondent. We essentially have been doing this, and we provide all of this information to them. Regardless, we've done this prior to the regs, and we will continue to do this. And the most important part is that we need to emphasize to the respondent that they are not responsible for the alleged conduct, and they're presumed not responsible. And it is not their responsibility to prove that they are not responsible. It's our obligation as the university to show that they are have violated policy by a preponderance of the evidence.
Yeah, we are basically emphasizing we have not prejudged anything in this. You know, we're not, when we send that notice out, it says we haven't decided anything yet. You know, this is just the allegations. This is your notice of it. This is your opportunity to meet with us and give us your take on it. But we are not prejudging anything at this point.
Also in that notice is the information that they have the right to an advisor of their choice, and that the advisor is permitted to accompany them to all of their meetings with the investigator, their meetings with all of you, that they have the obligation, they're allowed to review all the evidence that the investigator provides. That they are told that in that notice that they can be charged under the Student Code of Conduct for providing false statements during the grievance process. And this is difficult. I find this difficult because I think it'd be very hard to show that somebody willingly and knowingly provided false information. There's a big difference from your perspective of what happened in that incident that's being charged out than sending the investigator on, down a rabbit hole because you gave them false information. Very, very different. And if additional allegations surface from the incident, we need to provide them with written notice in addition to the initial notice of allegations. So we have to dismiss a formal complaint if it's determined that the conduct did not constitute sexual harassment as defined by our policy. The the activity didn't occur within the university's educational activity or was controlled by the university, and that the conduct didn't occur against a person in the United States, meaning this has to happen in the continental United States or Alaska, Hawaii. It can't happen, this doesn't apply to anything happening in a study abroad program. Or if there is a trip with let's say the French class went to France for 2 weeks. And that although it was an educational program or activity, if the incident occurred in France, it doesn't fall within our policy.
It doesn't fall under this policy.
This policy.
There are other ways that we can address those, but
exactly.
And
exactly.
will. Yeah.
So, and that at the time of the filing of the formal complaint, the complainant must be participating in or attempting to participate in an educational program or activity of the university. So if it is somebody who is not affiliated with the university, they would not have standing to bring this particular complaint. So we have discretionary dismissal as well. That we may dismiss the case if the complainant notifies the Title IX coordinator in writing that they would like to withdraw their formal complaint and the allegations, or the respondent is no longer enrolled or employed with the university, or specific circumstances prevent us from gathering evidence sufficient to reach a determination as to the formal complaint or allegations. And when this happens, if we are going to dismiss it on a discretionary basis, we need to provide both the complainant and the respondent with that notice. And if it is a mandatory or discretionary dismissal, both the complainant and the respondent are able to appeal that determination. And again, right to an advisor. More than one advisor can be present at a hearing in limited circumstances at the discretion of the Title IX coordinator, but only one of the advisors may conduct cross or actively participate in the hearing. Witnesses are not entitled to advisors within our grievance process. However, they may be advised externally. They can talk to a faculty member or someone else as far as the process, but they cannot have one with them during this process. An advisor can be anyone. If a party chooses an advisor outside of the pool that we have identified or are on our roster, they may not be familiar with our processes, but we cannot tell a student or faculty member or staff who they can and cannot have as an advisor. But for your purposes as hearing and decision makers, if they choose an advisor that isn't available or is unfamiliar with the process, you don't have to indulge the student and say, well, we'll keep putting off the hearing and put off the hearing until such time as that person is available. They have to have somebody who really is available and willing to serve as an advisor.
Yeah, this is where it gets a little bit, I don't know, almost sticky in terms of there's a lot of discussion about advisors and their role. And, we've tried to do as good a job as we can of breaking that down, but it really, it can be anyone of their choice. We say it can be a parent, it can be a friend, it can be, one of your academic advisors, it can be an attorney, but, doesn't have to be all of that. But like the folks that we have trained, we've got about 15 people just internally that we have trained. We know that they know our process and procedures, and they have had some practice in this, but we can't guarantee, we aren't going to be training just anybody. We're not going to be training so-and-so's friend, or even if they bring an attorney in. Like, the training that we have provided is for our folks. If we have to appoint somebody, if somebody shows up to a hearing without an advisor, because they need that person to ask the questions, to do the cross examination. And so,
The other crazy thing under these regs is that an advisor can also be a witness.
Yeah.
So
that's new.
Decision makers are going to have to determine credibility of an advisor / witness. So those are some of the rules that have been instituted by these regulations that we do have to follow.
Yeah, I mean, it can be kind of weird. So.
Do you want to take like does everybody want like a 7-minute break here where we can?
Yeah, if we just want to come back at 10:10, I think this is a good time to take a little breather, stretch, that kind of thing, and we'll come back and we'll probably be able to power through the rest of this.
Yes.
Pretty quickly. So
yes.
Let's come back at 10:10, everyone.
All right.
start asking everyone to come back, and we'll keep going here.
I did get an email from Bill, and he said that he is participating. He's just unable to activate his video and sound, but he said he is with us. So
Okay, awesome. Yeah. Okay, so I think what we'll go ahead and do as we get everybody back, we'll just go ahead and do our next question for purposes of CLE credit or just attendance in general. And so I'm going to ask everybody to just type into the chat, since we're kind of in the holiday season now, what is your favorite holiday? And it can be whatever, there's no right or wrong here, but just so that we can track attendance again. The poll question that we're asking everyone to put into the chat is, what is your favorite holiday? And if for some reason you can't type it into the chat, feel free to just send an email to myself or Christine with that information. You should have both of ours. You definitely have Christine's because you got the link. But yeah, just do that. And I think we just had, I'm trying to get Dave back. He had gotten disconnected and now he's coming back on.
okay, we did talk about this a little bit, about advisors. If they don't have an advisor, we have to provide them with one at the hearing. Hopefully, after all of your pre-hearing conferences with the parties, they will either have an advisor with them present, or obviously over Zoom or Teams, or you will have enough notice where you can tell them that they need to have an advisor by a certain time. And let me see, hold on, I think I have to let somebody in. They will have an advisor with them during these pre-hearing meetings, or you will be continually telling them that by the time of the hearing they need to have an advisor with them.
Yeah, you know, that's what it's going to look like. I mean, we will talk to them all the time. If they can choose not to have one for the investigative process. You know, they can choose to go to those meetings by themselves and look at all the evidence and everything by themselves. But when it comes time for a hearing, you got to have someone. And if you don't have somebody, then somebody is going to be appointed, because the regs require that piece of it.
Right, and you as the hearing panel and decision makers are going to need to assess whether or not the particular advisors are comfortable conducting this questioning. However, the way that we have arranged or set this up is most of the questions are going to be determined during the pre-hearing. That you will have the opportunity to work with these advisors, find out what questions they are going to be asking and things like that. So there may be some sticking points, but because of the way this process is set up, everything by the time you get to the hearing should run very smoothly. And especially knowing who the advisors are, their comfort level with questioning and the process, and whether or not the parties have advisors ready to go on the date and time of the hearing.
Yeah, and we will get into this a little bit here later in terms of what that pre-hearing conference looks like. But yeah, so yeah, I'm good to take it from here if you.
Yep.
Yeah. So. Okay, so again, the parties may be accompanied by their advisor in all meetings and interviews. They should and can help the parties prepare for each meeting. They are expected to advise ethically, integrity, in good faith, all of those things. Obviously, we can't control, if somebody has chosen a parent or a friend or something like that, we can't control that, but there is still that expectation if they are going to participate in our process to abide by that. And then the big one, we cannot guarantee equal advisory rights. If somebody chooses an advisor who is an attorney and the other party can't afford one or doesn't have one, we as a university do not have to provide an attorney to match that. And that has been an issue, a point of contention among our colleagues, across the country in terms of that. Is it fair? Is it really, equal or appropriate if somebody brings an attorney not to have another attorney? And really, there's nothing in the regs and there's nothing requiring us to, as the university, incur that cost, but also, that the advisor just doesn't have to be. And there's really nothing that says that just because somebody's an attorney, they're going to be better at this. I mean, there's a lot of folks who understand how these things work who are not attorneys. And so, it's really important because we think that argument may come up if, a complainant brings an attorney as their advisor and a respondent can't afford one and we don't provide them one, we provide one of our internal folks. Are they going to raise a fuss about that? Are they going to say, oh, it wasn't fair because they had an attorney and I didn't, but we are not obligated or required to do that. And then in terms of privacy, resolution proceedings are private, not specifically confidential, but private. We're not sharing this information with anyone who absolutely doesn't need to know. And, depending on the level of information shared, it's very much need to know. We're not going to share the bulk of the information with pretty much anyone unless they have to have it. But there's an expectation of maintaining that privacy. That members of the grievance pool are not going to discuss the matters outside of the proceedings. And then, that there is this expectation of privacy around what the investigators are going to share. The parties themselves have the discretion to share their own knowledge and evidence with others. And that is, something that we're running into this, or will, expect to run into this with things like people sharing their stories, on social media or online, or their experience of what's going on. We can't stop them from doing that. They have the discretion. Strongly encouraged to work with their advisors if they have one on that, share this information and hopefully get guidance from their advisors on what is appropriate to share on social media and what isn't. Again, we can't control that and wouldn't plan to, but there are things that could potentially compromise investigations, or there are things that might affect the way that we are able to look at information. But there is still that expectation that they're not supposed to share other people's evidence on social media. And if that happens, then there's obviously issues of retaliation and things like that to look at. So burden of proof is the preponderance of the evidence standard. The burden of gathering the evidence is the university's. That means that the burden does not lie on the complainant to show or prove that they, that this thing happened. But they are given the opportunity to provide evidence that they think is relevant. So that's, again, a lot of those screenshots, social media. Sometimes we have actual voicemail recordings. Occasionally we even have videos. People are with the phones and the cameras and everything, like they're taking videos. They have a lot of evidence that might be out there. But the university is then also, us as investigators are required to get that information. We have blue light cameras across campus and emergency phones and things like that. There are, key card. We have an entry system into a lot of buildings and things like that might end up being useful, if it's a housing issue or something like that. So it is our responsibility to get that information. We can't get it unless we know about it. So that's where the interviews and things come in terms of that. But they are given the opportunity to give us whatever information they think is relevant, and have a few different opportunities to do that. So we use that preponderance of the evidence standard for that. And then both parties are also provided that opportunity to present witnesses. And that does include fact and expert witnesses. I have not yet experienced that, but I have heard, you know, from other schools who have had that situation come up. And then other inculpatory and exculpatory evidence. So really, it's about that equal opportunity. Both sides have the same rights and opportunity in the process to present witnesses, evidence, all of that.
And also what you should know is we don't have, as a university, we don't have subpoena power. So if, for instance, there may be text messages that somebody does not want to share with us, we don't have the authority to go to the cell provider and subpoena the records. We won't subpoena a rape test kit, the results of a rape test kit. We don't have that option. We don't have that ability to do that.
No, that has to, you know, if people can get access to those things on their own, they can provide them to us, but that's the only way we can get them. So we are limited that way. And real quick, I know that we had a couple people join a little bit later. If you haven't answered the poll question is, what is your favorite holiday? And we just want to make sure we get responses from everybody for purposes of keeping track for attendance and CLE credit. Okay. So prior to completion of the investigation, the investigator, again, it's more than likely going to be me, it just kind of depends on our workloads, is going to prepare the report, the investigative report that summarizes the investigation. It's going to have the summary statements of the parties, witnesses, evidence, all of those kinds of things. And that includes those fact and expert witnesses. It is a report that it's basically going to have, you know, the timeline, you know, when the report came in, when the complainant was interviewed, when the respondent was sent the notice, when they were interviewed, the dates of the interviews of the witnesses. It's going to have all that laid out, any evidence that anyone has provided, and then it's going to have, you know, the undisputed facts. That's going to be, you know, one section, and then it's going to have the disputed facts based on the various accounts of the different people. And it's really just going to be, it's a summary, you know, it's different from the report that we have done previously, which had all of that information, plus then the investigator was the one who did the analysis and the determinations and things like that. And that part is now in strictly a hearing decision. And so, you know, the report is going to include all the directly relevant evidence, and those are going to be sent to each party and their advisors. So the investigator is going to also include any relevant evidence that we are not relying on, and then any other inculpatory or exculpatory evidence. And these are sent electronically simultaneously to both sides at the same time. So basically, you know, we're again just maintaining that everybody has the same opportunity, the same amount of time. You know, we're not sending one-to-one, you know, the first day and then waiting. You know, it's all at once. And so they're also given the opportunity to review the evidence beforehand. And there are these 10-day, you know, these are prescribed by the regulations. Once the evidence file is complete, both sides and their advisors, hopefully if they have them, are given the opportunity to review those evidence for 10 days, add if they need to, that kind of thing. And then the report is sent out and they have another 10 days to review the report and respond to that prior to the hearing taking place. Yeah, and so that's where, and that 10 days is to submit the response. If they want to, they have the opportunity, they are not required. That's important, is to note that they can, but they may not need to. They may look at that report and say, that is great, that's exactly what I said, that's exactly what I wanted to see from the other side, all of that, and they may not have a response, but they have up to 10 days to submit that if they choose to. And then the report will be sent to their parties, again, 10 days before the hearing. And that is to give people the opportunity to review and, again, respond if they need to. And, those 10-day windows are very long. That's not, it's 10 university business days. The overall process is supposed to take about, somewhere between 60 to 90 calendar days. A lot of that is in the investigative part, meeting with people, getting statements written down, those kinds of things. But adding that extra 10 days, it's really 20 days, because it's 10 days to review the evidence and then it's another 10 days to review the report, really adds on a lot of time to this process. But, within that time, that's when we're getting hearings scheduled. That's when we're getting our panels together, all of those things. That's all going to be happening during that process as well.
So the investigator will incorporate relevant elements of the parties' written responses.
Yes.
And that will be incorporated into the final investigation report, as well as any additional relevant evidence. The investigator will make any revisions to the final report before finalizing the report, and that the investigator will be documenting the rationale for the changes made after the review and comment period by the parties. So you will see all of that in the final investigation report. So once the final investigation report is transmitted to the parties, then we will notify, or we will reach out and select a panel of decision makers, including the chair. Again, we have a 3-panel decision-making process, and that important is that the decision makers haven't had any previous involvement with the investigation. They weren't contacted to serve as an advisor and couldn't, and that the people who served as investigators are witnesses at the hearing, and therefore cannot be decision makers either. And again, advisors can be witnesses. This could create a credibility issue for all of you, but we'll see what happens. We never know what to expect in these processes.
Yeah, it's entirely possible that an advisor who is a witness may be able to really, clearly kind of distinguish themselves in those roles. But our policy used to say that you couldn't, the advisor couldn't also be a witness, because that seems to, cause some of that those credibility issues to come into play. But, like Chris said, we don't know yet, because we haven't tested our process yet.
Again, we talk about the confidentiality. FERPA comes into play for us, and the Educational Rights and Privacy Act. What we would advise as decision makers is, especially during a hearing, not to bring your computer, and that you take handwritten notes, and that the handwritten notes are, we collect them at the end of that, so that there isn't that available. And we always tell everybody on your note, if you're taking notes, less is more. A lot of the information you will have, most of the information you will need, is in the investigation report. And we haven't done our jobs as an investigator if all that information is not available to you, everything you absolutely need.
Yeah, this is that FERPA, once it's written down and, once it's, in the record, it becomes part of what the students have the right to see. And so you got to be just cautious, in terms of that, and just being careful, because once it's written down and once it's there, it becomes part of their record and they can have it.
Again, what we talk about is being professional. This is an administrative process. We're all lawyers, or at least the majority of us are, and so it's really easy to slip into that judicial-like role. And even though that you will have the opportunity to ask the investigator questions or ask witnesses questions, we urge you not to do it in a interrogation-like manner. These are students. Most of them will be students. Some we might see an employee, but the main job is we are the keepers of the process, to make sure that the parties receive due process and that they are given a fair and equitable hearing and the opportunity to be heard.
Yeah, this is one of those things where, it's an information gathering process first and foremost. We're trying to get the most information possible to help you make that decision. Again, a lot of it will be in that report, but there may be something that comes out in the hearing. And so it's really about just, what are the blanks? What am I trying to fill in here? Help me understand, or I'm hearing you say this, I'm not sure how you got from here to here, those kinds of things, just to try and fill in the blanks, get the information that you are trying to get to be able to make that determination, of, was there a policy violation? Did this happen the way that, we think it did? So that's, not adversarial.
So once the panel is assembled, you will work with the Title IX coordinators to schedule a pre-hearing conference. All of these are recorded. They most likely will be taking place over Zoom or Teams, and you record them, and that's your opportunity to review the evidence with the investigator, the parties and their advisors. You will be talking about the admissibility of certain evidence. You will talk about what questions the advisors want to ask the other party or witnesses. And this is really to avoid the surprise questions. We want to make this hearing as predictable as possible for the participants. So that takes away a lot of the anxiety and a lot of the stress, and gives them a little more control in this whole entire process. There might be an opportunity for you during a pre-hearing conference where you stipulate to certain evidence, including party statements, that you all agree are just admitted. So you will have a lot of opportunity pre-hearing to determine how this process is going to work for the parties.
Yeah, it's really about setting the ground rules, establishing expectations and things like that. And, even though you can't prevent a surprise question from coming up, or depending on what somebody chooses to say, it might lead down a different path. But it's really, it's not supposed to be a gotcha process. It's not supposed to be catch you in the lie, or catch you in, your inconsistent statements, and things like that, which I think as attorneys, a lot of times that's what we're trained to look for, is the inconsistent statements, and how can we frame that. And this really isn't about that as much. That's for the hearing officers to determine, in the credibility part of the analysis, but it's supposed to be a situation that is predictable, like Chris said, you know, not supposed to be intimidating or, you know, deterring people from wanting to participate in the process. You know, really just, it's already traumatic for pretty much everyone, complainants and respondents alike. And so we're trying to reduce that as much as possible.
Again, you will have an opportunity to, before even the pre-hearings, to review the report and the investigator evidentiary materials. You will have an opportunity during all pre-hearing processes and even immediately preceding the hearing to answer any procedural questions, and the opportunity to review questions pertaining to the allegations. If you have a procedural question, you can always ask me or Sarah, who's ever serving as the Title IX coordinator at that particular point. We're there to help with all procedural questions. So, do any of you have any questions so far? Just holler.
Be a great opportunity to ask, you know, just whatever's kind of tickling your brain there about like, well, how does this work, or what can I look for, you know, those kinds of things. You know, and again, I think we've said that this is new for us too. You know, this is something that,
yeah. So if you don't have any questions, or if you think of something later, you can always email either Sarah or I, and we're happy to answer that. And otherwise, you will be receiving additional information from us and a Zoom link for part 2, which is on December 1st.
Yep, December 1st, 9 o'clock, and that will include, you know, a little more practice and, you know, really getting into the nitty gritty of what a hearing looks like. So hopefully, you know, if you'd like, you know, feel free to take a look at our policy. It's up on our website, 3.06. It's long, but very, like, I mean, it's long, but there's a lot of white space. Like, it's clear, you know, we think that it's pretty adequate for what we're trying to do. And we're in the process of revising it to make it a little clearer, but, you know, take a look at it and kind of look at the, you know, especially things like the sanctions and, you know, those sorts of things, just to get an idea of what we're doing. You know, we broke it down in terms of visuals, but it's super useful just to actually look at it and see what it says.
So, well, everybody, thank you. It was a pleasure meeting all of you over Zoom, and hopefully we will see most of you on the 1st.
Thank you.
All right, you have a good rest of your day. Thanks, everybody.
Thank you.